Hi, and welcome to Chapter 5 in your Commercial Law curriculum. Today we're going to talk about mutual assent of the parties. But before we do that, I want to just do a little bit of review, provide some context where we are in the semester. Remember in Chapter 1 and 2, we talked generally about the world of contracts and how they affect our everyday lives. We talked about the difference between contracts that are interpreted using the common law and contracts that are interpreted using the Uniform Commercial Code. And then from chapter 3 and 4, we started to talk about the elements of a contract. All of the elements need to be present in order for you to have a valid and legally binding agreement. So in chapter 3, we talked about the formation of a contract between the offeror and the offeree. We talked about the offer and the acceptance. In chapter 4, we talked about consideration, right? The value for the promise. And today we're going to talk about mutual assent. And when we're talking about contracts, remember we're talking about agreements between people. So it should come as no surprise that in order for us to have a valid and legally binding agreement, both of the parties have to assent. They both have to understand the basic terms, the basis of the agreement. So after reading this chapter, you should be able to define mutual assent. You should be able to list the methods of destroying mutual assent, what I call mutual assent killers. You should be able to contrast the different elements of fraud and misrepresentation, which are a couple of those mutual assent killers. Determine when mistake destroys mutual assent, and differentiate between procedural and substantive unconscionability. So one of the most important parts of a contract is, as we said, the agreement. And mutual assent is another way to talk about the agreement. The parties must willingly and genuinely assent to the terms of the contract, or the contract may be invalid. And we call this mutual assent, or a term you'll hear used a lot in contract law is a meeting of the minds. Under this concept, we're looking for open and honest dealings between the parties so that they understand the basis of the bargain. So the communication and the offer, the acceptance leads to the agreement because both parties understand what they're getting into, and thus it's a necessary element of the contract. Now, to determine whether or not mutual assent exists, the courts will apply an objective standard. We've talked about this before. And that means that they're going to step back and look at the actions and the dealings and the words that the parties use and decide whether there's any way it could reasonably be concluded that the parties had an intent other than to be bound by the contract. So the courts are generally going to assume that mutual assent is there, but they're going to use this objective standard and say, is there any other outcome other than mutual assent, other than a contract that we can find here? And then we're going to look at the sort of defenses to a contract. Now, even if we otherwise believe that we have mutual assent, there are certain things that can happen that can destroy mutual assent. These are sort of defenses to contract. And again, I refer to them as mutual assent killers. We're going to talk about each one, but they are fraud, misrepresentation, mistake, duress, undue influence, and unconscionability. Now, as we said, we want the parties to agree to the basic terms of the contract. We want to have that mutual assent. And a problem arises when the parties are not honest or genuine with each other, or if they make mistakes in their contractual negotiations. When terms are deliberately omitted or mistakes occur, the parties are placed under undue pressure. The contracting process suffers because we don't have this free will and this open agreement. Exhibit 5-1 in your book gives a good listing of the methods of destroying mutual assent. We're going to go through each one. Now, the first method of destroying mutual assent that we talk about is fraud. And you recognize it when we start talking about it. Essentially, what we have here is one of the parties lying or trying to trick the other party into signing an agreement. So they're not being open and honest. They're not being truthful in their dealings. By definition, fraud is a statement of fact or omission of fact, knowingly made by one party with the intent to induce the other party to enter into a contract. And all of those elements have to be present. All the elements you see here in the presentation have to be present. First, there has to be some misstatement of fact. But just having a misstatement of fact is not good enough. It has to be a fact that was material to the other party, the victim party, if you will, in making their decision as to whether or not to enter the contract. The knowledge of the fraud and the intent to deceive are important. In other words, the person who is perpetrating the fraud has to know that what they're doing or what they're saying is false, and they have to be making that misstatement of fact in order or with the intent to deceive the other party. Next, back over to the other side, the victim in this case has to rely on that deception, and there has to be some damages associated with that reliance. So there's got to be a misstatement of fact, has to be material to the other party's decision. The person who's perpetrating the fraud has to know that they're perpetrating a fraud and do so with the intent to deceive or lure that other person in. On the other side, the person who's being lied to has to rely on whatever misstatement of fact was given, and then there has to be some damage based on that reliance. And those are the elements of fraud. You have to prove each one in order to use fraud as a defense to a contract or a destroyer of mutual assent. So what happens if one of the parties commits a fraud? Well, essentially the person who is the victim in this case has the power to void the contract. If they are injured in some way, then the power to void rests with them. They can void the contract, they can sue for money damages, and they can also just cancel the contract. All right, our next mutual assent killer is misrepresentation, and it looks a lot like fraud. They have very similar characteristics. The difference is that the misrepresentation is a misstatement of fact that is made innocently without the intent to deceive. So as a way to explain the difference, let's look at the example your book gives. Let's say that you go to buy a car and you ask about the odometer. Is the odometer accurate? The salesperson tells you that yes, the odometer is accurate. If the salesperson knows for a fact that the odometer had been cracked open and that mileage had been rolled back, and you rely on that fact to your detriment, then we have a fraud. If, however, the salesman tells you that the odometer is accurate because they have no reason to believe that it's been rolled back, then we have an innocent misstatement of fact. So that's the difference between fraud and misrepresentation. The outcomes are similar. The other elements are similar, but the difference is in the knowing misstatement of fact versus the innocent misstatement of fact. So what about the duty to disclose facts? In other words, do you have a duty to tell the whole truth, or is it okay to just leave some things out, omission? The answer is that it depends. If the omission is material, it becomes part of the basis of the bargain, something that would have changed the buyer's mind. If they had known it, then yes, you do have a duty to disclose. In addition, if there's some statute that the legislature has promulgated that requires a disclosure, then of course, yes, you have the duty to disclose. We see that a lot in real estate. So let's take an example again from your book. Let's say that you're selling a house and you know that termites have eaten away at the foundation to the point where it's ready to fall down. You bring a potential buyer in, you walk them around the house, but you fail to mention anything about the foundation. Well, clearly that is a fact that probably would have affected the buyer's decision whether or not to purchase the house. And so you have a duty to disclose the fact that there's a problem with the foundation. Another example of where there's a duty to disclose and where we really raise the bar on our requirements is where there's a fiduciary relationship. It means a person in a position of trust. If you're a person in a position of trust, like a lawyer-client, banker-client, or something like that, you have the utmost duty of good faith and loyalty. So, and again, I'll go back to an example in real estate. There's a fiduciary relationship between a real estate agent and the people that they're helping to buy a house. So if your real estate agent knows that they had the problem with that foundation in our previous example, and they don't tell you, then they have definitely breached that duty to disclose. As we move down the line here, we'll talk about mistake, and we're going to break it up into two parts and talk about mutual mistake, where both parties are wrong about some material fact, and unilateral mistake, where just one of the parties is wrong. It's an important distinction. Mutual mistake is where both parties are wrong about a material fact of the transaction, and thus the court will often rescind that contract. That's because both of the parties came to the table and didn't really understand what they were contracting for. There is one caveat to that. If only one of the parties wants to get out of the contract, they can't be the one that bears the risk of identifying or clearing up the mistake. Give an example again out of your book. If two parties are selling a condo, one selling, one buying, and the seller believes that the condominium is something that overlooks a parking lot, the buyer thinks it is a condominium that overlooks the ocean. When they finally come down to the table, they realize the mistake. They both made a mistake about the condo, and only the buyer wants to get out because they thought they were getting an oceanfront condo. But they bore the risk of buying something without checking it out first. So they can't rescind the contract on their own. It has to be a mutual mistake where both parties want to get out of it. So in the case of a mutual mistake, if only one party wants to get out, they can't be the one that bears the risk of clearing up the mistake. Now let's talk about unilateral mistake. For unilateral mistake, we only have one of the parties not understanding. One of the parties is wrong. And in this case, the contract is usually going to be enforced unless we have some other mutual assent killer like unconscionability. Okay, the next couple of mutual assent killers are very similar. And when we talk about these, we want to keep in mind that in order to come to an agreement, you have to come to the agreement of your own free will. And the next couple of mutual assent killers remove that element of free will. The first one is duress. Duress means wrongful pressure placed on a person so as to deprive him or her of free will. For an action in duress to be sustained, all of the elements must be proven. And the party alleging duress must show that the pressure or the force that was brought to bear on them was extreme, and had the pressure not been exerted, they would never have entered into the contract. So we're talking about things like threats of violence, threats of physical imprisonment, the threat to take or keep some personal property, or the threat to breach the contract. Undue influence is very similar in that we're removing free will, the free will to enter into an agreement. But we usually see this when we're dealing with a party who is in a position of responsibility. Take, for instance, caretakers of the elderly or the ill, or fiduciary responsibilities or fiduciary relationships like trustees, partners, and lawyers. Right? In these cases, we're expecting the caretaker or the fiduciary to always have the elderly person or the ill person or the client's best interest in mind. And when we bring a charge of undue influence, what we're saying is that that person who had a position of responsibility and trust and was supposed to be taking care of someone abused that position of trust and got them to change their mind, brought undue influence, and therefore we don't have the free will entering into that agreement. That's a mutual assent killer. Okay, unconscionability, one of those great words to take home for Thanksgiving, right? We can destroy mutual assent if the courts believe that this contract shocks the public's sensibilities, and therefore it is as a matter of public policy, we don't want this contract to ever happen. We're going to break this up into two parts, procedural and substantive unconscionability. Procedural is in dealing with the formation of the contract. In other words, we have one party who has all of the facts and one who has none of the facts. One party lacks an understanding of the terms. Maybe through illiteracy, infirmity, language barriers. In other words, they're not understanding what they are agreeing to, and if you don't understand what you're agreeing to, you don't have mutual assent. We sometimes talked about these contracts as contracts of adhesion. They have extremely harsh terms. One side had all the bargaining power. We usually see these contracts in a pre-printed form where there's no way you can negotiate the terms. Let's talk about substantive unconscionability. That's after the formation. We look at the terms, and they're oppressive or they're unreasonably harsh. The prices are so high as to be unconscionable. If something goes wrong in the contract, one party fails to perform, the remedies are very one-sided. Or if one party fails to perform, the consequences of non-performance are extremely harsh. They're unconscionable. They shock the conscience. And again, as a matter of public policy, these are things that the legislature or the court system or the public in general just doesn't want to happen. So let's just wrap up and summarize everything. Mutual assent is a necessary element of a contract because what we're trying to get to is an agreement, a meeting of the minds. Mutual assent is found when the parties have the same understanding of the terms and conditions of the contract, and it can be destroyed by things like fraud, misrepresentation, mistake, duress, undue influence, and unconscionability. That's all we have for this week. As always, if you have any questions, don't hesitate to contact me. I hope you have a great week, and I'll see you next time.